And finally, Ashley McDermott, partner at Mayer Brown, to talk about the legal issues. Ashley, over to you.
Thank you, Sean. Thank you, Deepesh. So as the guys say, my name's Ashley McDermott. I'm a partner at Mayer Brown. Mayer Brown's an international law firm, for those of you that are not aware. I would encourage you to take a look at our COVID-19 portal, the address of which is on the front cover of the slides in front of you. I primarily cover loan transactions, including structured trade finance, and some receivables work. And I'm going to talk today through some of the aspects that we're seeing in relation to the current climate and questions from clients, some contractual remedies that you may be able to look at, and also some possible changes that we expect to last beyond the current period of uncertainty. So moving quickly on, in these highly unusual times, the earlier speakers have spoken about some of the things that they're seeing in the market. From our perspective, we're getting a lot of questions about possible covenant breaches, amendments to documentation that's required, questions around insurance policies, and also questions about the impact and extent of new laws that are being passed almost on a daily basis, ranging from stay-at-home orders in most jurisdictions, lockdowns, to moratoriums in some jurisdictions on repayment of debt. So a broad range of things. As I say, this session is quite a whistle-stop tour, but hopefully it will be useful for you in looking at a few of the things that we're being asked. So moving beyond the overview slide, I spoke about what we're going to say today, so we'll move straight on in the interest of time to the most pressing issues slide. And you'll see that in this slide, I divided the sections into three. We're getting practical questions, we're getting legal questions, and we're also getting a few questions on insurance. So taking each of those points in turn, on the practical side, obviously the current climate has a huge human impact. And so clients of ours and yours, I'm sure, are trying to still perform as much as they can their obligations to their counterparties and their clients, but also protect their staff and comply with the rules. And that's been a moving target and a constant battle keeping up with the rules, but also putting in place things that are going to work and allow businesses to perform. IT, well, as many of you will know, many banks and other institutions, law firms, etc., now have very strict policies when it comes to confidentiality and security of IT. We're seeing that is butting up against the need to have flexibility in order to allow transactions and business to continue when everybody's working from home and unable to access printers and scanners and that sort of thing. It's quite a detailed topic, but suffice to say, we aren't seeing many institutions give much flexibility to their employees or their professional service providers when it comes to that, on the basis that the information confidentiality and security requirements cannot be waived or amended much, even in light of the current situation. So we're getting quite a lot of questions on that. We're seeing registry offices being closed, so things like Companies House and other registries around the world. Notaries are finding it very difficult, if not impossible, to turn up to meetings to notarize documentation, which has had an impact on signings and closings and will continue to do so. And lastly, presenting. We've seen banks finding it very difficult to present documents in the trade finance context, and that has caused delays. We saw that in Asia, and we're seeing it now coming into Europe and the US a little bit. So moving on to the second section, what are the legal questions we're looking at? Well, a lot of those so far have revolved around signings. So what can people do in terms of signing documents electronically? This is one of the areas where I expect the changes that we've seen, even in the last 2 weeks, to continue beyond the current period of economic and social uncertainty. We've seen a very fast adoption by almost all of the law firms, at least in the London market, to using electronic signings. And a large part of that goes back to a QC's opinion that the London legal market obtained from Mark Hapgood QC in 2014, but it wasn't hugely adopted because people could still use wet ink originals, wet ink signatures, because they always had done. So that is a positive development, and I expect that to continue, and people being more flexible around using electronic signatures and platforms such as DocuSign. A note of caution on that, of course, is we all work in cross-border transactions. It's the very nature of trade, and it is challenging in some jurisdictions to rely on that. So you always need to check with the lawyers in the jurisdictions of your counterparties. It can also be difficult to register documents sometimes if you're using anything other than a wet ink original, for example in the UK at the Land Registry. And lastly, we've been looking into the question of whether negotiable instruments such as bills of exchange can be signed electronically and emailed rather than in paper form, wet ink original, and kept in bank vaults, etc. Particularly interesting perhaps to many on this tradecast. Just finally, I'll talk about insurance briefly. David touched on it or talked about it a lot earlier. We are getting questions where clients, banks, counterparties are very closely looking at the wording in their insurance policies, the exclusions, the non-payment insurance policies, exactly what is covered and what is not, and we expect that to continue. So moving on to the next slide, how do you assess your existing contracts? Well, this is something which lawyers will be doing every day of their careers, but it's important, I think, to just go over a few of the key concepts here, just to make sure that you're aware of the best practice in this respect, in respect of your own contracts. So firstly, we recommend identify what contracts you need to look at, and indeed which are of the highest priority. So that may be because they're a very important counterpart, a supplier of yours. It may be because they're of high value. It may be both. And then once you've identified those, what are your options? So we get a lot of people asking questions and printing client briefings around force majeure, frustration, legal concepts such as this. My advice to you and to your clients would be take a look at the agreement itself first before you jump to those parts, because it may be that we've seen examples where actually there was flexibility in agreements in terms of delaying payment periods, or being flexible in terms of the obligations of suppliers, etc., in distress scenarios. If those don't exist, of course, you can look at concepts such as force majeure and frustration, and we'll come to those a little later. Something which is often overlooked is a notice requirement. So often many contracts of different types will have an obligation on one party to the contract to notify others if certain events arise. And that's particularly important when it comes to things like trade insurance and notifying your banks of any sign of distress. Often that's a very advisable thing to do. It can start the claim periods, counting, etc. So don't forget about those. Another thing is, what messaging and communications do you want to put out to your counterparties? We expect a lot of the current distress to be resolved either amicably or at least outside of a court process. Most of the contracts that we're all party to never envisaged a period like we're going through now. So we expect, as a commercial practical matter, parties to try to be flexible as much as possible. So think about the messaging and the style that you want in terms of formal communications with your counterparties. You need to strike that balance between being flexible and helpful and trying to maintain relationships, whilst also not meaning that you have basically waived your rights later on if things do turn out to be not amicable and you end up in a dispute. Watch out for jurisdictions that have concepts such as mitigation of loss. So many jurisdictions require people to mitigate their loss. The extent to which that's possible in this current environment is another question, but that's something worthy of note. And finally, do talk to your lawyers wherever possible. This is not an easy area. Each contract is different. Each law governing contracts have different approaches to things. So I would recommend you reach out to lawyers internally and externally to the extent possible. So moving on just to the next slide, how do you amicably resolve a dispute or make amendments to your contracts? Again, a wide-ranging area, but the one thing I would say to take away from this is that be clear. The extent to which you're amending your existing contractual terms, agreeing to a different regime, perhaps you're agreeing to extend payment terms, as I said earlier, or something similar. Is that a temporary arrangement or is it permanent? If it's temporary, how long should it last? Only during the period of a lockdown? Further, you need to be clear in the documentation you sign setting about the revised arrangements, what you're agreeing, and whether you're agreeing to walk away, I would say shake hands, but not shake hands, walk away, or whether it's just a temporary arrangement and you're trying to mitigate loss in the short term. And finally, do you need to discuss any such amendments or resolutions to a dispute with third parties such as banks and insurers, as I mentioned earlier? Moving quickly on to the legal concepts, force majeure, frustration, and others. I've set about a bit of detail on the slides here. I don't propose to go through it all. There's a lot of case law in English law alone, and each jurisdiction has different views of these concepts. I'll give a short summary in relation to frustration and force majeure because I think they will helpfully set the scene as to how easy it is to rely on them. So force majeure allows a party affected by an event beyond its control to suspend its obligations under that contract. Deals such as project finance transactions have very heavily negotiated force majeure provisions, very detailed. Many contracts don't. They may refer to force majeure alone, they may list certain events. Not many have actually listed pandemics and things of that nature. So it may not be easy to rely on that concept legally. We've seen very recently people like Primark have told suppliers that they're stopping all orders and not paying for existing orders on the basis of force majeure. I expect those types of transactions may end up going to court, and we'll watch this space. Frustration is where there's an impossibility to perform a contract, to perform your obligations under the contract, so the contract should be set aside. So even more difficult to prove in many cases. I think it will be especially difficult for companies in a supply chain to rely on concepts such as this because on the one hand, particularly long supply chains, on the one hand, you'll be looking at your own suppliers, asking them to perform. It makes it then difficult potentially to turn to your customers and to claim force majeure or frustration. We have lots more notes and information on our website, as I say, including a COVID-19 portal. So I would encourage you to look at that to see what more is out there. But in terms of changes for the future, I think that people will be more used to electronic signings and working remotely, and hopefully there'll be some that will continue, and there'll be some other developments as we work through this period together. Thank you very much, and I hand back to Deepesh for questions.